want to understand the position of the NDC legally first, and then tactically what they are doing next. So, Honorable Ayariga, thanks for joining us, and I know you are very busy this morning, so let's just make it straight to the point. So, on Thursday, we know that Speaker Bagbin made a ruling. Is it my understanding that for the NDC, that is the ruling that stands, that despite the stay of execution that the Supreme Court declared or issued on Friday, the minority's understanding, or the NDC's understanding, is that Speaker Bagbin's ruling stands? Is that how I should understand the position of the NDC in Parliament?
Yes, that's our position, that we will act according to Speaker Bagbin's communication until he communicates otherwise. So if what is said to have been done by the Supreme Court is served on Speaker Bagbin, and he comes to Parliament and communicates anything to us on the basis of what he has heard from the Supreme Court, we will act according to the communication given to us by Speaker Bagbin, because we are in a coordinate branch of government, which is the legislature. We listen to our Speaker. We don't listen to the Supreme Court. And in any case, we, the minority, were not, the minority at that time and now the majority, were not part of the proceedings, were not a party to the action in court, and the court hasn't spoken directly to us.
Will your view have been different if this was served on notice? So maybe on Friday they went and then you were served, and then on Monday you were to go to court to hear for the stay. Would this have been a different posture? Are you ignoring the Supreme Court because they went ex parte?
We are ignoring the Supreme Court because we are a coordinate branch of government, and the Constitution is very clear that the Supreme Court should not interfere in our work. We are protected by the Constitution. If you look at Article 115 of the Constitution and Article 122 of the Constitution, it protects the integrity of our proceedings and says that those proceedings should not be impeached or questioned in any court, including the Supreme Court. So it surprises us that the Supreme Court, which is supposed to be the body that understands the Constitution better than anybody, will see Article 115 and still go ahead to impeach our proceedings without even so much as, listening to the side of the Speaker in Parliament. So we would have taken the same position even if they had invited her. But if they had invited the Speaker, perhaps they would have benefited from all the arguments that today we are making. And many senior lawyers are making the same argument that, look, this is not a matter that even should have been entertained by the Supreme Court. This is a matter that should have started at the High Court, because Article 99 is very clear on the subject, that when it comes to a question of whether or not a seat is vacant, that is a matter that is reserved for the High Court. If there is some misunderstanding, the High Court can then stay proceedings and refer it to the Supreme Court. Then the Supreme Court can give the High Court guidance as to how to go about the matter. This is the structure of the Constitution. And we expect the Supreme Court to understand this. Maybe if it had said, look, let's not be in a hurry. Oh, today is Friday, there is Saturday, there is Sunday, there is Monday. The Parliament will not sit until Tuesday. So let's just invite them. Let's hear the urgency. What's so urgent about this matter that you are forcing us to act within 24 hours of your filing of an application? They would have benefited from superior wisdom. They have to be guided by lawyers. If you go and listen to one lawyer, you can easily be misled. And that is what has happened. They've been misled.
Some are saying that if the Speaker chooses to disregard or not abide by the Supreme Court's ruling, he essentially will be held accountable for what is called a high crime, quoting Article 2, 3 and Article 4, that he will be in contempt of the court. Do you understand this? Do you agree with this?
I think that we should wait and hear from the Speaker on Tuesday before we start speculating and saying all these things. Like I said, to tell you the truth, I have a problem with the understanding of some of these judges of our Constitution. if provisions as basic and clear as Article 97, 99, 115, 122, 130, if provisions as basic and as clear as these ones can be so gravely misconstrued by these judges, I don't know what they understand by the provisions that trigger high crime. I don't know whether they understand the provisions that relate to high crime. And of course, they haven't said this. You are the one saying that some have said. So I'm not sure any judge has said.
No,
that
I'm just referring. Yeah, I'm just referring
yes,
to.
It's just analysts. But I'm saying that I don't know if these analysts understand what really a high crime is. That I disagree. A coordinate branch of government disagrees with another coordinate branch of government that it is supposed to exercise supervisory authority on. People have forgotten that the legislature in some jurisdictions is actually the most supreme. In the UK, the legislature is almost sovereign. In Ghana, we tampered with the sovereignty of the legislature and limited it. So people should not forget that it is actually Parliament that has supervisory jurisdiction over the two other coordinate branches of government. That is why the powers of impeachment of both the legislature and the judiciary is given to Parliament. So we are supposed to be supervising them as well, in the same way that they're also supposed to be interpreting and enforcing the Constitution. So we are co-equals and coordinate branches of government. We are not a hierarchy where the Supreme Court is superior to the executive, to the legislature. No.
Okay.
We are not.
Finally, some people are saying we could be in a position where the speaker can also say the judges are in contempt of Parliament. So that if the court says that the speaker is in contempt of court, Parliament could also say that the court is in contempt of Parliament, and we have a double contempt, leading to a constitutional crisis. Now, as a constitutional lawyer yourself, how do we avoid this? I mean, you've explained the NDC position and you've told me what you would do tactically, but now I'm asking you a general question around this very possible constitutional crisis that if both sides, and by that I mean if the Speaker and the Supreme Court decide to hold entrenched positions, there will be obviously a constitutional crisis. How do we wriggle our way out of that?
We are a human society trying to regulate ourselves by writing down how we should regulate ourselves. We've written it down in the Constitution. Though you and I didn't write it, those who crafted it wrote it, and then we have accepted it and feel bound by it. The provisions in Article 122 on contempt of Parliament are very, very clear. That if you do anything that affronts the dignity of Parliament, and the Speaker, who is the one to interpret the rules of Parliament, and such conduct concludes that it is contempt, then it is contempt. The same way, the courts, by practice, have also developed contempt powers, where they feel that if you challenge their authority and you undermine their integrity and image, the same way the Constitution says they should also not undermine the integrity and image of the legislature, then you are in contempt. So both institutions have contempt power, but in the case of Parliament, it is expressly written into the Constitution as a protection for Parliament. If that arises, then I believe that it provides an excellent opportunity for the institutions, the coordinate institutions, to talk to each other. And when they talk to each other, they will resolve it, and they will learn from it, and tomorrow they will all behave properly. And let me conclude on this issue. It happened before. In the U.S., in the case of Baker and Carr in 1968, the U.S. Supreme Court learned its lessons and said, look, you know what? Don't get involved in politics. Don't get involved in matters that are the preserve of the coordinate branches of government. When a matter can lead to controversies like that, where one branch of government will say one thing and another branch of government will say another thing, please, Supreme Court, stay away from it. And that is what is called the political question doctrine. And this is a classic case of a political question that the Supreme Court should have just stayed away. Because if you read the proceedings of Parliament, of the Supreme Court, and the kind of things that the judges said, when you go to the section where it says by court. You see them saying, oh, that there will be chaos in the country, that there will be stalling of government business in Parliament, that the budget may not be passed, that the NDC caucus will repeal certain laws, and that they intend to take certain actions to reconstitute the committee. These are all political matters that the Supreme Court should not be interested in. If the NDC in Parliament does that, and so what? Is that your business? Is that our business as a court? It's not our business. Go and deal with it as a political matter. If the electorate votes and then NDC is the majority in the Parliament, can we, the Supreme Court, sit in the court and start saying that no, don't block the minority government from passing the budget, don't reverse legislation, don't constitute committees? These are all political matters that are governed by the rules of Parliament. So in Baker and Carr, the Supreme Court said, look, Supreme Court, stay away from these matters, because these are matters reserved for the politicians who constitute the executive and constitute the legislature. So we don't want to get involved. We will only get involved if there is a serious issue about what the words of the Constitution actually mean. We will just tell you what we think is the meaning and leave you. And then it's your responsibility to do whatever you want to do with our understanding of the meaning. That is all. But to jump in and start saying the things that the courts were saying, as if you are a branch of the NPP. Why are you foot soldiers? Why are you worried about whether the NPP is able to protect the e-levy law in Parliament? Why are you worried about whether or not they pass the budget? You've been watching CNN. Sometimes Congress cannot pass budget. The Supreme Court is sitting and watching them. How they pass the budget, they talk to each other. And finally, they come to a compromise. Then they remove the provisions that the Republicans don't want, or add the arrangements that the Republicans want captured. Then the Republicans come on board and they pass it for them. These are pure political matters that the Supreme Court shouldn't get involved in.
All right. I'll leave you now. Thank you, Honorable Ayariga. This is a free development. We'll talk again, I'm sure. Tomorrow will be an interesting day. Mama